19219 Statute Law, Function, Jurisdiction, and Structure Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 19 inches. Part 1 Introduction to the Law, Function and Structure. The concept of lawmaking jurisdiction is explained in Chapter 1. Statute law, legislation, is the formal, written law enacted by governments. Canada has three principal levels of government: federal, provincial, and municipal, and each level has a specific law-making jurisdiction, or sphere of appropriate legislative action, reserved to it. In countries with a federal system of government, a system that contains a number of semi-autonomous units, these levels are a common way of organizing legislative responsibility. However, the degree of control given to the smaller units of government varies widely from federation to federation. As a general rule, the central government in a federation tends to reserve to itself jurisdiction over very important issues or issues of national importance, including crime, national security, immigration, and trade. Issues of daily life, such as employment and family law, are assigned to the smaller governmental units. In Canada, a comparatively large degree of legislative responsibility is delegated to the provinces and territories, that is, there are many more provincial statutes and accompanying regulations than there are federal ones. A coherent organizational scheme for assigning jurisdiction is important because it prevents legislative overlap while ensuring that all of the issues that need to be addressed are covered. An organizational scheme also allows for shared governmental responsibility, including financial responsibility, for administering the legal system. Decisions about which level of government has jurisdiction over a particular issue often create political tension in a federation. While the smaller units of jurisdiction authority to make law, either by governments or by courts. Learning outcomes. After completing this chapter, you should be able to explain the concept of jurisdiction with respect to lawmaking. List the principal levels of lawmaking jurisdiction in Canada. Describe the function of the Constitution in establishing lawmaking jurisdiction. Describe, in general terms, the division between, and scope of, provincial and federal jurisdiction. Explain the process for creating statute law. Explain how to locate a statute. Describe the typical structure of a statute. Describe the function of regulations. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 20 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure. 21 Government often prefer to have the power to decide a particular issue. Having that power usually means being responsible for the cost of its administration. See the case in point feature on services in Indigenous communities for an example of how courts decide questions about constitutional jurisdiction. How is the legislative jurisdiction for statute law determined? In Canada, as in many federations, legislative jurisdiction has been established by a constitution. A constitution is considered to be the law that creates, or constitutes, a nation. It is a basic plan for the government of a major political unit, in our case, Canada. Canada was created in 1867 by an act passed by the British Parliament now cited as the Constitution Act, 1867, one previously known as the British North America Act 1867. In 1982, the British Parliament passed the Canada Act 1982, which contained the Constitution Act, 1982.3. The Constitution Act, 1982 was passed by our Parliament and includes the Canadian Charter of Rights and Freedoms. For the passage of these pieces of legislation by both the British and Canadian parliaments meant that Canada officially had a constitution and that this constitution was completely Canadian. The Constitution Act, 1982 states that it, and therefore the Charter, is the supreme law in Canada. No single government, federal or provincial, can change the Constitution. The Charter will be discussed in greater detail in chapters 4 and 6. One of the most important tasks performed by any constitution is the assignment of legislative jurisdiction, which is also known as the division of powers. In the case of the Constitution Act, 1867, this assignment is made by sections 91 and 92, which read, in part, as follows: 91. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada, in relation to all matters not coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, and for greater certainty, but not so as to restrict the generality of the foregoing terms of this section, it is hereby declared that notwithstanding anything in this Act, the exclusive legislative authority of the Parliament of Canada extends to all matters coming within the classes of subjects next hereinafter enumerated, that is to say, 1. Repealed. 1a. The public debt and property. 2. The regulation of trade and commerce. 2a. Unemployment insurance. 3. The raising of money by any mode or system of taxation. 4. The borrowing of money on the public credit. 5. Postal service. 6. The census and statistics. 7. Militia, military and naval service, and defense. Cite, describe or refer to, orally or in writing, a legislative provision or legal decision. Copyright 2021 M. and Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 21 inches. Part 1 Introduction to the Law, Function and Structure. 8. The fixing of and providing for the salaries and allowances of civil and other officers of the Government of Canada. 9. Beacons, buoys, lighthouses, and Sable Island. 10. Navigation and shipping. 11. Quarantine and the establishment and maintenance of marine hospitals. 12. Seacoast and inland fisheries. 13. Ferries between a province and any British or foreign country or between two provinces. 14. Currency and coinage. 15. Banking, incorporation of banks, and the issue of paper money. 16. Savings banks. 17. Weights and measures. 18. Bills of exchange and promissory notes. 19. Interest. 20. Legal tender. 21. Bankruptcy and insolvency. 22. Patents of invention and discovery. 23. Copyrights. 24. Indians, and lands reserved for the Indians. 25. Naturalization and aliens. 26. Marriage and divorce. 27. The criminal law, except the constitution of courts of criminal jurisdiction, but including the procedure in criminal matters. 28. The establishment, maintenance, and management of penitentiaries. 29. Such classes of subjects as are expressly accepted in the enumeration of the classes of subjects by this Act assigned exclusively to the legislatures of the provinces. And any matter coming within any of the classes of subjects enumerated in this section shall not be deemed to come within the class of matters of a local or private nature comprised in the enumeration of the classes of subjects by this Act assigned exclusively to the legislatures of the provinces. 92. In each province, the legislature may exclusively make laws in relation to matters coming within the classes of subjects next hereinafter enumerated, that is to say, 1. Repealed. 2. Direct taxation within the province in order to the raising of a revenue for provincial purposes. 3. The borrowing of money on the sole credit of the province. 4. The establishment and tenure of provincial offices and the appointment and payment of provincial officers. 5. The management and sale of the public lands belonging to the province and of the timber and wood thereon. 6. The establishment, maintenance, and management of public and reformatory prisons in and for the province. 7. The establishment, maintenance, and management of hospitals, asylums, charities, and eleemosynary institutions in and for the province, other than marine hospitals. 8. Municipal institutions in the province. Copyright 2021 M. and Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 22 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure 23(9). Shop, saloon, tavern, auctioneer, and other licenses in order to the raising of a revenue for provincial, local, or municipal purposes. 10. Local works and undertakings other than such as are of the following classes: a. Lines of steam or other ships, railways, canals, telegraphs, and other works and undertakings connecting the province with any other or others of the provinces, or extending beyond the limits of the province. B. Lines of steamships between the province and any British or foreign country. C. Such works as, although wholly situate within the province, are before or after their execution declared by the Parliament of Canada to be for the general advantage of Canada or for the advantage of two or more of the provinces. 11. The incorporation of companies with provincial objects. 12. The solemnization of marriage in the province. 13. Property and civil rights in the province. 14. The administration of justice in the province, including the constitution, maintenance, and organization of provincial courts, both of civil and of criminal jurisdiction, and including procedure in civil matters in those courts. 15. The imposition of punishment by fine, penalty, or imprisonment for enforcing any law of the province made in relation to any matter coming within any of the classes of subjects enumerated in this section. 16. Generally all matters of a merely local or private nature in the province. Tribunal, a formal body established, often under a statute, for the purpose of adjudicating disputes within the ambit of the statute. Case in point: constitutional jurisdiction and services in Indigenous communities. The question of whether a government activity falls under federal or provincial jurisdiction is especially complicated where the activity takes place on First Nation reserve territory. First Nations and other Indigenous communities in Canada often have their own systems of government, and there is an increasing willingness on the part of non-Indigenous governments in Canada to interact with these governments on a quasi-nation-to-nation basis, that is, the way one country interacts with another country under international law. However, as provided by treaties and other agreements, Indigenous communities often receive funding from other Canadian governments, both at the federal and the provincial territorial level. Typically, funds from a province are given to support on-reserve activities that are analogous to services under provincial jurisdiction, while federal funding often has a more general purpose, for example, to support self-governance efforts and efforts to achieve an acceptable standard of living in reserve communities. In the case in question, a tribunal formed in 2012, the British Columbia Human Rights Tribunal (BCHRT), heard arguments in Pritchard v. Lawman Community Health Board Society. In this case, an individual named Hugh Pritchard was fired as the executive director of the Lawman Community Health Board Society, the society, an agency that operated on a First Nations reserve and offered services similar to those provided by a provincial or territorial child and family services society. Pritchard alleged discrimination in relation to the termination and filed complaints with both the Federal Canadian Human Rights Commission and the provincial, British Columbia Human Rights Commission because he was unsure which commission had jurisdiction over the case. The BCHRT was required to decide which Human Rights Commission had jurisdiction over the case. Previous decisions, jurisprudence, about these kinds of cases make it clear that the answer in these cases is highly fact-specific. The tribunal must consider all of the relevant evidence and cannot only rely on one. Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 23. Part 1 Introduction to the Law, Function and Structure. Considering the hundreds of statutes currently in force in Canada, it is surprising that this jurisdiction plan is relatively simple. Because the plan was created in 1867, many of the issues that are currently the subject of legislation had not even been contemplated by the constitutional drafters. Consider, for example, legislation designed to regulate telecommunications. How, then, do the provinces and the federal government determine which has jurisdiction over new or unique issues? The answer: By analogy, when an issue that requires legislation comes up, it is compared with the matters specifically addressed in the jurisdiction sections of the Constitution SS 91 and 92, and it is then assigned to either the provinces or the federal government based on where the issue seems to fit according to the intentions behind the original division of powers. In many cases, this is an easy decision and is a matter of agreement between the levels of government. When the decision is more contentious, the courts are called on to interpret the application of the Constitution to the new issue. For example, credit cards, deciding factor in making its determination. The jurisprudence also made it clear that facts related to funding, for example, where does the money to run the service come from, and facts related to the nature of the service, that is it more like a provincial or federal service, are relevant to the analysis that the tribunal must undertake. The BCHRT noted that the Sliman First Nation, where the society operated, receives funding from the federal government to provide health programs and services. However, the First Nation argued that the society operated independently of the First Nation. The society itself received funding from the province of British Columbia to permit it to offer child welfare services as an alternative to having the First Nation come within the operational jurisdiction of the province's own Child Protection Department. This arrangement exists on several reserves because many First Nations consider the right to provide their own child welfare services to be an important aspect of self-government. Child and family welfare services have long since been recognized as falling within the jurisdiction of the provinces and territories. In essence, the question before the tribunal was whether the operations of the society were 1. More like provincial child and family services, which would mean the matter would fall under the jurisdiction of the Provincial Human Rights Commission, or 2. More like services involving Indians, and lands reserved for the Indians, S. 91, Item 24, of the Constitution Act, 1867-5, which could theoretically make the society a federal agency that would be governed, for the purpose of labor relations disputes, by the Federal Human Rights Commission. The tribunal decided that, based on the facts it had to consider, the society fell under the jurisdiction of the province, and therefore the British Columbia Human Rights Commission would be charged with handling Pritchard's complaint. In finding that the operations of the society were not primarily about Indians and lands reserved for the Indians, the BCHRT reflected the modern-day tendency to move away, whenever possible, from the older historic pattern of federal influence and control over indigenous peoples and instead to support a reserve's progress toward autonomy over the provision of services on its lands. Questions for discussion 1. Do you believe DT treating services provided on reserve as analogous to provincial services is consistent with a nation-to-nation approach to relations with Indigenous peoples in Canada? Why or why not? 2. Notice that although he was employed by an agency operated by a First Nation, Pritchard needed to bring his complaint before an agency operated by the province of British Columbia, the British Columbia Human Rights Commission. From the perspective of the First Nation, does this requirement support or undermine its goal of greater autonomy? Should First Nations create their own human rights commissions? What would be the likely benefits, drawbacks, and/or obstacles? Source: Pritchard vs. Lawman Community Health Board Society, 2012 BCHRT 152. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 24 inches. Chapter 2 Statute Law. Function, jurisdiction, and structure 25 such as Visa or MasterCard, are regulated by federal law, even though credit cards did not exist in 1867. Banks handle the business of credit cards, therefore, by analogy, it makes sense to have credit cards fall under federal jurisdiction. To help clarify how the division of powers works in practice, here are two lists of statute names. The statutes in the first list are federal statutes, and the statutes in the second list are provincial statutes. Federal statutes passed by the Parliament of Canada: the Criminal Code, 6th the Immigration and Refugee Protection Act, 7th the Aeronautics Act, and 8th the Oceans Act. 9 provincial statutes passed by provincial legislatures: the Family Law Act 10, Ontario, the Workers' Compensation Act 11, Alberta, the Human Tissue Gift Act 12, British Columbia, and the Municipal Act 2001-13, Ontario. Municipal jurisdiction sections 91 and 92 of the Constitution, reproduced above, include scant mention of municipal jurisdiction. However, certain legal issues in Canada are addressed by municipalities, cities, and towns. You will notice that specific items in Section 92 of the Constitution refer to municipal or local matters, see items 8, 9, and 10, and thus the provinces have jurisdiction over municipalities. Laws passed by municipalities are called bylaws and usually deal with issues of a very local nature, such as parking, waste collection, and community services. Municipalities hold the authority to regulate these issues by delegation, passing down of responsibility from the provinces and territories. Although many issues that are considered part of municipal jurisdiction may seem minor in comparison with national concerns, the smooth management of a large municipality is an incredibly complicated task and can give rise to an enormous number of bylaws. Municipal law is a very complicated discipline and, apart from this brief mention, is beyond the scope of this text. What is the process for creating statute law? Once the jurisdiction for a new law is determined in accordance with sections 91 and 92 of the Constitution, the corresponding level of government, federal, provincial, or municipal, progresses through a series of steps to create the new statute. The exact nature of these steps differs slightly depending on the level of bylaws. Laws made by a municipality that govern such issues as parking, noise control, licensing, and property standards, can include offenses and penalties. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 25. Part 1 Introduction to the Law, Function and Structure Government. However, the overall process of drafting the preliminary version of a law, known as a bill, and then debating, amending, and voting on the bill before it is passed to create statute law is common to all levels of government. Figure 2.1 provides an overview of how a bill progresses through these steps to become statute law. Bill: a preliminary version of a statute law that is written down to be reviewed, debated, and voted on before becoming law. Figure 2.1 How a bill becomes statute law. Idea: all laws start with an idea. First reading: the purpose of the bill is explained, and it is printed. Second reading: the principle of the bill is debated. Committee and report stage: committee members study the bill in detail, sometimes hold public hearings to improve the bill, consider amendments, and report the amended bill back for a final debate and vote. Third reading: the bill is debated, and there is a vote on the amended bill. Royal assent: after being passed, the bill is signed and becomes statute law. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 26 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure. 27 Federal laws affecting all Canadians, such as the Criminal Code, are passed by Parliament in Ottawa. Bills have a first reading in one of two chambers, either the House of Commons or the Senate, where the purpose of the bill is discussed. The next step is for the bill to have a second reading where its strengths and weaknesses are debated. The bill is then sent to committee where any changes, called amendments, are made. The amended bill then goes back to the original chamber where it is read a third time, debated, and voted on again. If the changes are passed after the third reading, then the bill is sent to whichever chamber the bill did not originate from. In the other chamber, the bill goes through the same process of being closely studied by committee and debated before being voted on. If the other chamber makes any changes to the bill, these changes must be sent back to the original chamber for approval. Once the same bill containing the same language is passed by both the House of Commons and the Senate, then it is signed by the Governor-General to receive royal assent. The same process of debating, amending, and voting on bills is used by provincial legislatures to create provincial laws. These provincial statutes create laws that are enforceable within their respective province. However, in contrast with federal bills, only one provincial assembly votes on bills instead of two. In Ontario, bills must successfully pass through 3 readings in the Legislative Assembly before receiving royal assent from the Lieutenant Governor of Ontario and being proclaimed into force as statute law. As was discussed in the previous section, municipalities have the authority to pass bylaws that address issues within their local boundaries. This authority is derived from the jurisdiction assigned by the Constitution to the provinces over municipal and local matters. Individual municipalities have their own procedural requirements for creating a bylaw that determine, for example, whether a public meeting regarding the proposed bylaw is required or whether a third reading of the bill for the proposed bylaw is required. However, the overall process of reviewing, amending, and voting on the bill before it becomes statute law and is enacted as a municipal bylaw mirrors the process at the provincial and federal levels of government. Criminal law, civil law, and the administration of justice. Criminal law and civil law are the primary themes of this text. As was discussed in Chapter 1, it is important for all students of the Canadian justice system, whether in police foundations, law and security administration, paralegal, or law clerk programs, to be aware of the distinction between these two areas of law. The distinction plays out in a variety of ways. For example, as noted in Chapter 1, the procedures used to enforce the criminal law are very different from those used to enforce the civil law. Another example is the source of authority for a police officer or a security officer. Does the authority to act, for example, to arrest copyright 2021 M. Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 27 inches. Part 1 Introduction to the law, function and structure or to charge come from a federal statute, a provincial or territorial statute, or a municipal bylaw. A third example lies in the administration of justice. You may have noticed in the lists of legislative jurisdiction above that there appears to be an overlap in the area of criminal law. Criminal law is discussed under Section 91, Item 27, as a federal matter, but it is also discussed under Section 92, Item 14, as a provincial matter under the topic of the administration of justice. A closer examination of these items shows that federal jurisdiction and provincial jurisdiction are divided. Procedure in criminal matters comes under federal authority, but the Constitution of Courts of Criminal Jurisdiction does not. That function comes under provincial authority. As you progress through the courses in your program, the practical effects of these two areas of legislative jurisdiction will become more apparent. For now, it is sufficient for you to know that the federal government has the authority to set out the criminal law, for example, through the criminal code, and to prescribe the procedure for processing criminal charges, while the provincial and territorial governments have the authority to run the courts and to set the procedure for civil matters when a person or company sues another person or company. Protesters outside of the Parliament buildings in Ottawa rallied to support the decriminalization and legalization of recreational cannabis use in Canada. After much debate in Parliament and the media, Bill C-45, an act respecting cannabis and to amend the Controlled Drugs and Substances Act, the Criminal Code and other acts, and Bill C-46, an act to amend the Criminal Code, 14 were passed by the House of Commons and the Senate. As a result of these statutory changes, using cannabis for recreational purposes became legal on October 17, 2018 in Canada after being prohibited since 1923. Copyright 2021 M. Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 28 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure 29 Researching Statute Law. The Criminal Code. The statute that police consult most often is the Criminal Code. The most current version of this statute is cited as RSC 1985, CC 46. The significance of the elements of this citation will be discussed below. Because it is one of the most frequently consulted Canadian statutes, the Criminal Code is often published by commercial case in point. A single incident can result in charges under different statutes. On December 24, 2009, 4 construction workers in Toronto who worked for Metron Construction fell 13 stories to their deaths at a high-rise apartment building when the overloaded scaffolding they stood on broke apart. Subsequent investigations revealed that the construction project manager had permitted 6 workers to board the scaffolding on the day of the accident, even though he was aware that there were only 2 lifelines available to secure workers to the platform. Following the accident, charges for 61 quasi-criminal offences were laid by inspectors of the Ministry of Labour for violations of the Ontario Occupational Health and Safety Act. 15 In parallel, police laid criminal charges against Metron Construction under Section 217.1 of the Criminal Code for criminal negligence causing death in personnel against the construction project manager for failing to take reasonable steps to prevent bodily harm to persons completing work under his direction. Representatives for Metron Construction pled guilty to the criminal charge, leading to a $750,000 fine against the corporation. The project manager pled not guilty to the criminal charge and in a landmark decision was convicted of criminal negligence causing death, resulting in a prison sentence of 3.5 years. This was the first time in Ontario that an individual was found guilty under the Criminal Code for offences related to their failure to take reasonable steps to prevent harm arising from work they had the authority to direct another person to complete. The significant prison sentence imposed by the trial judge was upheld on appeal and sent a strong message of accountability to those responsible for maintaining workplace safety. Although the criminal charges against the president of Metron Construction were ultimately withdrawn by the Crown prosecutor for lack of evidence, the president was personally convicted of 4 charges under the Ontario Occupational Health and Safety Act that resulted in fines totaling only $90,000. The resulting public outcry resulted in the maximum fines for individuals and companies under the Occupational Health and Safety Act being raised to $100,000 per conviction for individuals and $1,500,000 per conviction for corporations. Together, the combination of quasi-criminal offences available under the provincial statute and criminal offences under the federal criminal statute provides the tools for provincial inspectors, police, and Crown prosecutors to prevent future workplace tragedies. Questions for discussion. 1. Sentences for quasi-criminal offences, including those under the Ontario Occupational Health and Safety Act, can result in penalties of large fines and even incarceration that exceed those for criminal offences. Do you believe it is necessary to govern offences concerning the same type of incident under more than one statute? 2. The Canadian legal system has evolved so that multiple statutes govern the behavior expected in society. As a result of this, not all harmful acts qualify as crimes. To maintain social values, do you believe that it would be more effective to criminalize a broader range of behavior? Sources: RV Metron Construction Corporation, 2013 ONSA 541, RV Kazanelson, 2018 ONSA 77, and RV Swartz, 2012 ONCJ 505. Quasi-criminal offences: offences that are prohibited by provincial and federal statutes that have penalties similar to criminal offences but are subject to less complex court procedures and do not result in a criminal record. Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 29 inches. Part 1 Introduction to the Law, Function and Structure. Publishers in both pocket editions and annotated editions that contain commentary, many of which contain the text of other related statutes, such as the Youth Criminal Justice Act, 16 the Canada Evidence Act, 17 and others creating criminal or quasi-criminal offences. These editions typically also include the text of the Charter of Rights and Freedoms. Current, commercially published editions of the Criminal Code will serve most research needs, but because such editions are usually published once a year, new provisions or amendments may not be included. To be absolutely sure that the information is up to date, for example, to prepare for a court appearance, one needs to update, or note up, research results by consulting an official source, that is, a version of a statute or regulation that meets the court's standards for legitimacy, accuracy, and currency, for the legislation, as described below. Other statutes. Although the Criminal Code figures prominently in legal research, there will be occasions to apply or be familiar with other statutes that have a quasi-criminal component, for example, the Smoke-Free Ontario Act, 2017. 18. Many of these statutes will be discussed in a course on provincial offenses. Because these other statutes are not as commonly applied by police officers, usually no convenient pocket edition is available. Finding these statutes requires performing basic legal research in the same way that a lawyer or paralegal does, that is, in a traditional law library or on a computer. There are a number of computerized databases, including government websites which contain cases, statutes, and regulations. The Canadian Legal Information Institute website called CanLII, which is managed by the Federation of Law Societies of Canada, and commercial online resources such as Lexis Advance QuickLaw and Westlaw Next Canada. Is the legal problem covered by a statute? In some cases, it may be necessary to research a legal problem without even knowing whether the problem is covered by a statute, because a great deal of Canadian law is case law, as explained in Chapter 1. In such a case, the first step might simply be to describe the problem to a more experienced colleague or to a law librarian who may be able to identify the relevant statute. Figure 2.2 may help you visualize the typical steps used when researching a legal issue. A statute may also be identified by performing a keyword search. For example, if the problem deals with a tenant who claims to have been locked out of their apartment by the landlord, the search for the relevant statute might be based on the word landlord or the phrase locked out. Resources are often available in both electronic and paper form. Which form is used may depend on availability, cost, and ease of use. Common examples of each form are discussed below. Official source: a version of a statute or regulation that meets the court's standards for legitimacy, accuracy, and currency. Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 30 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure. 31 Electronic sources. An electronic source for legal research, such as a database or website, will likely have a search function that allows searches by keyword. The kinds of documents generated by such a search will depend on the type of source, but if there is a statute governing the legal question, there is a good chance that it can be found this way. As with any website, the user should make sure that the site contains accurate and current information. The federal government and most provincial governments maintain websites that include the full text of statutes. Current versions and consolidated, updated versions of the statutes and regulations found on Ontario's e-laws website, http://www.ontario.ca/laws, now have official status. Similarly, all consolidated statutes and regulations found on the federal government's Department of Justice website, https://laws-lowest.justice.gc.ca/eng/acts, are official versions. 32 Part 1 Introduction to the Law, Function and Structure. Paper sources. Legal research can also be done in a law library using paper sources. The librarian can identify any encyclopedic sources that may be available. The most common ones are the Canadian Abridgment Carswell, a huge, multi-volume legal encyclopedia that is searchable in many different ways. It is a good idea to ask a librarian how best to use it, and the Canadian Encyclopedic Digest Carswell, another large encyclopedia that is organized primarily by subject matter. The Canadian Encyclopedic Digest has regional editions, so the appropriate one for the region should be used. Although these encyclopedias may look daunting, a keyword search will often quickly reveal the name of a statute, or a case dealing with the particular legal problem. In the case of the lockout example set out above, a search under landlord will almost certainly lead to a provincial or territorial statute concerning landlord and tenant law. All of the provinces have a similar statute. Using the citation to find the statute, a reference to a statute will also likely provide the statute's citation, a list of letters and numbers following the statute name that represent that statute's address, for the purpose of research. A federal statute's citation looks like this: Criminal Code, RSC 1985, CC 46, or Immigration and Refugee Protection Act, SC 2001, circa 27. A provincial statute's citation looks like this: Provincial Offences Act, RSO 1990, CP 33, or Employment Standards Act, 2000, C 2000, circa 41. A statute citation is designed to direct the reader to the most current official source for the legislation. Historically, each Canadian legislature, federal or provincial, published a print collection of its statutes. This included new volumes, printed each year, containing all new legislation passed by the legislature. People consulted these print sources as their primary means of accessing the content of statutes. Previously, the practice had been to publish a collection of statutes on a periodic basis with any changes or revisions. For example, Ontario published its revised statutes every 10 years. Now that most people access statutes online, the creation of print revisions consolidations has stopped. The 2 or 3 letters that immediately follow the statute name in the citation identify whether it forms part of the revised statutes or the annual statutes. RSC 1985 means Revised Statutes of Canada, 1985 revision, while SC 1994 means Statutes of Canada, 1994. The same is true for provincial legislation. RSO 1990 means Revised Statutes of Ontario, 1990 revision, and SC 1995 means Statutes of Ontario, 1995. The abbreviations differ for other provinces. Citation and expression, in standard form, of the bibliographical information for locating a case or legislative document. Copyright 2021 M. Montgomery Publications. Chapter 2 Statute Law. Function, Jurisdiction, and Structure. 33. For example, RSA means Revised Statutes of Alberta. See Appendix A for a list of abbreviations. This part of the citation, then, identifies which volume contains that statute. The rest of the citation is a chapter reference indicated by a lowercase c that tells where in the volume to look for the statute. Revised statutes are usu ali catalogued or cited by a combination of the first letter of the statute and the numerical position under that letter. For example, the Criminal Code is CC 46. Statutes that have been passed since the last revision of statutes for that government are numbered consecutively for the year that the statutes were passed, and no initial letters are used to identify the chapter. For example, the citation for the Cannabis Act that was passed by Parliament in 2018 is SC 2018, circa 16 inches, which indicates that the statute is part of the 2018 publication of the Statutes of Canada and that it is located in Chapter 16. In the past, if a researcher needed to review a new statute or amendment to an existing statute so recent that it wasn't in the last annual volume, they would need to consult a print publication such as the Canada Gazette, that is the official publication of Acts of Parliament by the Government of Canada, or an equivalent provincial or territorial service for government bills. For example, the Ontario Gazette publishes new statutes and amendments passed by the Legislature of Ontario. Today, bills and their status are widely available online. Also, when amendments have been passed but are not yet enforced, sometimes there is a delay. For example, when an administrative system needs to be created to support the changes, the pending provisions appear as gray shaded text in the online statute so that the researcher can see what changes are contemplated. Updating a statute while the citation directs researchers to the statute, this is never the end of the process. Most statutes, not only ones that are frequently revised such as the Criminal Code, are updated occasionally by Parliament through the process of amendment, which involves passing new substatutes that make changes to the main statute. These amending statutes may be found in the statute volumes following the most recent volume of revised statutes. The revisions are incorporated into the statutes on the government websites. Reading a statute. Basic principles of statutory organization. Having found a statute, a researcher needs a plan of attack for reading it, especially if it is long. A few statutes, especially longer ones, are published with tables of contents and even indexes, but most are not. Fortunately, most are organized according to a standard pattern, which may include the following features. Copyright 2021 M. Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 33 inches. Part 1 Introduction to the Law, Function and Structure 1. Long title. Usually, this is written as, an act respecting, the subject matter of the statute. The long title is rarely used to refer to the statute. 2. Short title. This is the name by which the statute is commonly known, which may be provided at the beginning or at the end of the statute. If a short title is provided, it is the only way the statute may be properly cited. 3. Preamble and introduction, made up of one or more provisions. The preamble sets out the objectives and guiding philosophy of the statute. The preamble can often provide some interesting insights into the socio-political context of the statute. It is also an official component of the statute for interpreting and enforcing the statute. 4. Introductory provisions. These often include a list of defined terms, a description of the scope of application of the statute, and details about how the statute will be administered. 5. Body of the statute. The sections in this part of a statute deal with the substantive issues covered by the legislation. In a long statute, the body may be divided into a number of parts, each of which deals with an aspect of the statute. Provisions dealing with the same aspect are grouped together in the same part of the statute. Where a statute imposes penalties for breach of its terms, these provisions are often found near the end of the body or near the end of individual parts. 6. Housekeeping provisions. Housekeeping provisions, found at the end of some statutes, deal with administrative issues, such as the timing of coming into force of individual provisions. Briefly skimming a statute before beginning to actually read it may help to identify sections that are most likely to contain the information sought, especially if the statute contains shoulder notes, that is, brief references in the margins that describe the content of the provisions. Shoulder notes are not officially part of the statute, but are meant to help readers access the different provisions. Headings are helpful for the same purpose. Regulations. Many statutes are accompanied by a type of subordinate legislation known as regulations, particularly where the subject matter being covered is of a technical nature. Unlike statutes, regulations are not passed by Parliament or provincial legislatures. They are prepared and published by administrative officials, department or ministry staff, under the authority of the relevant statute to deal with the technical issues. Regulations tend to be very practical and can include lists, schedules, diagrams, forms, and charts. The rules of various levels of courts are generally published in the form of regulations. Preamble and introduction, made up of one or more provisions, that sets out the objectives and guiding philosophy of a statute. Housekeeping provisions. Provisions found at the end of some statutes that deal with such administrative issues as the timing of coming into force of individual provisions. Shoulder notes. Brief references in the margins that describe the content of the provisions. Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 34. Chapter 2 Statute Law, Function, Jurisdiction, and Structure 35 The information contained in regulations is just as important as that found in the primary legislation. It is often even more current because regulations do not require the formalities of the legislative process to be created, they can and do change frequently. This flexibility is one of the reasons they are used. For example, Ontario's Employment Standards Act, 2020 has numerous regulations, including one that addresses emergency leave due to infectious disease that was implemented shortly after the beginning of the COVID-19 pandemic in 2020. If a statute has regulations made under it, the regulations will be published in their own volumes, separate from the statute, and they will be revised according to the same schedule as the statute itself. However, regulations cannot exist on their own without a parent statute. For a regulation to lawfully exist, the statute must include a provision that designates regulation-making authority. If no such provision exists, no regulations can be drafted. Regulations are available online on government websites. For example, in Ontario, statutes and regulations are available on e-laws. Although the primary focus of this textbook is criminal and civil law, a key role for police officers is the enforcement of regulatory, or quasi-criminal, laws. This includes statutes such as the Highway Traffic Act 21 and the Compulsory Automobile Insurance Act 22 that impact the daily lives of Canadians as they go about their business. In Ontario, the offences flowing from regulatory laws such as speeding tickets are prosecuted in Provincial Offences Court, which forms part of the first level of provincial trial courts known as the Ontario Court of Justice. For other regulatory statutes such as the Occupational Health and Safety Act, enforcement officers other than police may be appointed to investigate potential violations and lay charges under the authority of the respective act. While convictions under these regulatory laws may result in steep fines or even incarceration in severe cases, they cannot result in a criminal record for the offender and so are quasi-criminal in nature. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 35 inches. Chapter 2 Statute Law, Function, Jurisdiction, and Structure 37-6 Criminal Code, RSC 1985, CC 46-7 Immigration and Refugee Protection Act, SC 2001, Circa 27-8 Aeronautics Act, RSC 1985, CA 29 Oceans Act, SC 1996, Circa 3110 Family Law Act, RSO 1990, CF 311 Workers' Compensation Act, RSA 2000, CW 1512 Human Tissue Gift Act, RSBC 1996, Circa 211-13 Municipal Act, 2001, CA 2001, Circa 2514 Bill C-45, an act respecting cannabis and to amend the Controlled Drugs and Substances Act, the Criminal Code and other acts, SC 2018, Circa 16, and Bill C-46, an act to amend the Criminal Code, SC 2018, C-2115 Occupational Health and Safety Act, RSO 1990, CO 116 Youth Criminal Justice Act, SC 2002, C-117 Canada Evidence Act, RSC 1985, CC 518 Smoke-Free Ontario Act, 2017, CA 2017, Circa 26, Schedule 319 Residential Tenancies Act, 2006, CA 2006, Circa 1720 Employment Standards Act, 2000, CA 2000, Circa 4121 Highway Traffic Act, RSO 1990, CH 822 Compulsory Automobile Insurance Act, RSO 1990, CC 25 Exercises Multiple Choice 1. Legislative jurisdiction over a particular subject matter is determined a. by the courts, b. by the Constitution, c. by analogy, d. on a first-come, first-served basis, a, b, or c2. If you suspect that the statute you are seeking was passed within the last 12 months, you could look for it a. in the most recent statute volumes, b. in the newspaper, c. in the Canada Gazette, an equivalent provincial bills service, or official online consolidated version, d. any or all of the above, e. b or c3. The preamble of a statute, a. deals with substantive issues covered by the legislation, b. deals with administrative issues, c. sets out the objectives and guiding philosophy of the statute, d. lists housekeeping provisions, e. gives the long title of the statute, 4. The abbreviation, RSC 1985, stands for A. Revised Substantive Code, 1985 Revision B. Revised Statute Constitution, 1985 Revision C. Revised Statute Citations, 1985 Revision D. Revised Statutes of Constitution, 1985 Revision E. Revised Statutes of Canada, 1985 Revision Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 37 inches. 38 Part 1 Introduction to the Law, Function and Structure 5. A bill, A, is a draft statute that is being considered by Parliament. B, is a statute that has just been passed by Parliament. C, is a provision of a new statute. D, is a statute that is in the process of being amended. E, is a substatute of an existing statute. True or false, _________1. If a provincial statute is currently in force, you will always be able to find it in the revised statutes of the relevant province _______2. All statutes have accompanying regulations ______3. Marriage licenses are issued by provincial agencies, but divorce is governed by a federal statute ______4. Canada's constitution was actually passed as a statute of the British government ______5. Diagrams, schedules, and charts are common features of regulations ______6. A commercially published edition of the Criminal Code is an official statutory source ______7. All services delivered on First Nations reserves fall within the jurisdiction of the federal government ______8. The building and management of railways falls under federal jurisdiction ______9. Municipalities have the authority to provide services because those services are delegated to them by provincial, territorial, or federal governments ______10. The procedures that apply in criminal courts are prescribed by the Criminal Code itself, not by the civil procedure rules of the provincial court in the province where the criminal offense is prosecuted ______11. All bills must be read, reviewed, and voted on by the Senate before becoming statutory law. Short answer 1. Consider the names of the statutes below and the division of powers set out in sections 91 and 92 of the Constitution. Which level of government do you think passed each of these statutes? For each statute, cite an item number from section 91 or section 92 to support your answer. A. Workplace Safety and Insurance Act. B. Bank Act. C. Meat Inspection Act. D. Highway Traffic Act. E. Broadcasting Act. F. Business Corporations Act. 2. You are a police officer who receives a telephone complaint from a citizen who is irritated by the loud flapping of their neighbor's Confederate flag. The large flag is mounted prominently above the neighbor's front door. The complainant also believes that the flag is a racist symbol because of its connection to the historical practice of black slavery in the American South. As a black Canadian, the complainant feels that as well as being a source of noise pollution, flying this flag in a suburban Ontario neighborhood is a form of racial harassment. Identify legislation in your jurisdiction that deals with the issues noise, flag flying, racist symbols raised by this complaint. What are the relevant sections of the legislation you identified that address the legal questions in this scenario? Based on your review of the legislation, is the flag flying neighbor guilty of any offense? 3. You learned in this chapter that the municipal level of government regulates issues such as waste collection, parking, and community centers through delegation of regulatory authority from a province or territory. Research Copyright 2021 Emmond Montgomery Publication. Chapter 2 Statute Law, Function, Jurisdiction, and Structure. 39 The following issues with respect to municipal jurisdiction. A. Are all Canadian communities within organized municipalities? B. Does this mean that there is no government waste collection in some communities? 4. Identify a statute, for example, using an internet keyword search about an issue, such as water quality testing, or student loans. See if you can answer the following questions about the statute. A. Is it federal or provincial territorial? B. In what year was it introduced? C. Who proposed it? For example, was it a government-sponsored statute, or was it a private member's bill? D. What prompted the passage of the statute, that is, was it a court decision, an event such as an accident or natural disaster, the emergence of a new social problem, or some other circumstance? Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with Image for page with label 39 inches.